Hello everybody, welcome to iExamB's Legal Beat. This is Amrita, your law faculty here at iExamB. Embrace the iExamB learning experience with us and don't forget to subscribe to our YouTube channel that is Legal Beat. Legal Beat is the exclusive law channel of iExamB. इस चैनल पे हम लोग काफ़ी सारे वीडियोस लेकर आते हैं in which we keep on discussing with you content that is relevant for competitive exam preparation and also the strategies of the preparation of various exams. We also try to bring up the videos that are relating to the current topics or current affairs and the law behind it. So ये सब आपको लीगल बी पर मिलेगा. डोंट फॉरगेट टू सब्सक्राइब. एंड अगर आप iExamB की कोर्सेज चेकआउट करना चाहते हैं, द ऑनलाइन कोर्सेज आर अवेलेबल एट www.iexamb.com. इन कोर्सेज की डिटेल्स एंड इवन डेमो ऑफ द कोर्सेज इज अवेलेबल एट दिस वेबसाइट. So you can check it out. You can also call us on the number 920-5524028 and also write us an email in case of query on hello@iexamb.com. So the topic that I am going to take up today is based on a statement that was recently given by the Honorable Chief Justice of India, Mr. D Y Chandrachud sir. He has talked about the famous principle of jail is a rule or exception. Jail is a rule and not an exception. ये स्टेटमेंट ऑलरेडी लेड डाउन है, बट इस पर क्वेश्चन उठाया है हमारे चीफ जस्टिस ऑफ इंडिया ने. ऑनरेबल CJI has discussed this in a very recent conference of the district judges. Why was he questioned on this? Though it is an established principle that was a judicial contribution, no doubt it is not a legislature that has enacted this principle, but it is a judicial contribution. It is a golden judicial contribution. But then why is Honorable Chief Justice of India questioned on it? Let us know that. The All India District Judges Conference was held at Kutch on 2nd of March, very recently. So the Honorable Chief Justice of India has expressed a concern regarding the apparent reluctance of district courts to entertain matters that are concerning personal liberty. इसका क्या मतलब हुआ? जो भी district judges हैं उनके पास जो भी bail applications जाते हैं, because what is concerning personal liberty is what is bail cases. What is the meaning of bail? Whenever you are charged for any offense and you are under an arrest, either you are under an apprehension of arrest, तो आप एंटिसिपेटरी बेल के लिए फाइल कर सकते हैं, या फिर अगर आप ऑलरेडी अरेस्ट हो चुके हैं, यू आर प्रोड्यूस्ड बिफोर द मैजिस्ट्रेट, यू गो फॉर द प्रोसीजर ऑफ रेगुलर बेल. सो व्हेन इट कम्स टू द बेल ऑर्डर, द डिस्ट्रिक्ट जजेस आर बीइंग रिलक्टेंट. This has been observed by the Honorable Chief Justice of India and he has expressed his concern over this in the conference. Because personal liberty is a fundamental right. So if you are putting somebody in jail, you are curtailing his personal liberty. So whether it is not a exception and a rule, this thing is being followed, या फिर इसका उल्टा हो रहा है. Whether it is an exception and not a rule, इस चीज़ को अगर हम उल्टा देखें तो फिर काफ़ी सारे बेल्स के मैटर्स में बेल नहीं दी जाएगी. सो इस तरीके का जो कंडक्ट है डिस्ट्रिक्ट जजेस का, दे आर बीइंग रिलक्टेंट, इस पर CJI ने स्टेटमेंट दिया है. द स्टेटमेंट इज देयर इज ऑल्सो अ राइजिंग एप्रीहेंशन दैट द डिस्ट्रिक्ट कोर्ट्स आर इंक्रीजिंगली रिलक्टेंट टू एंटरटेन मैटर्स कंसर्निंग पर्सनल लिबर्टी. द लॉन्ग स्टैंडिंग प्रिंसिपल विच सेज bail is the rule, jail is the exception, seems to be losing ground, as evidenced by the growing number of cases that are reaching high courts and the Supreme Courts as appeal against the rejection of bail by the trial courts. We can stop here for a minute. When we are talking about the number of cases reaching the High Court and Supreme Court, that is quite big, quite huge number of cases are coming. So these are coming as appeal against the rejection of bail that is being passed by the trial court judges, by the district judges. Why? Because they are being reluctant. This has been observed. This trend warrants a thorough re-evaluation. I want to hear from our district judges why this trend is emerging across the country. Now this statement has been passed in the conference, and really if this thing has been said by our Chief Justice of India, this becomes a matter of concern and this has to be reevaluated as he has mentioned. क्योंकि अगर हमने कोई प्रिंसिपल जुडिशियरी में डेवलप किया है एंड उसको इम्प्लीमेंट नहीं किया जा रहा है, and that is indirectly affecting, I would say not indirectly, directly affecting the fundamental right of a person, then definitely that needs to be reevaluated. If a person is behind the bars, definitely, and yes, especially the under trials, those who are still under trial and they are not getting the benefit of being outside, they are not being released on bail even after sufficient period of investigation has passed, then that is really an area of concern. Bail is a rule and jail is an exception. This principle has originated in the case of state of Rajasthan versus Balchand urf Balia in 1977. It's a very old principle still, we can say that. And this was developed by Honorable Justice Krishna Iyer. It was stated that basic rule may perhaps be tersely put as bail, not as jail. यानी कि अगर हमें चूज करने के लिए कहा जाए, हम एक नॉर्मल लेमैन लैंग्वेज में समझते हैं, तो आपने हमेशा बेल को चुनना है. यानी कि वी शुड ट्राई टू गिव बेल टू द पर्सन इफ ही इज एबल टू प्रोड्यूस सफिशिएंट श्योरिटी, if he is able to produce himself for all the investigations, there are no chances that he is going to tamper with the evidence. All these are the necessary conditions for bail. So the court should try to give bail and not just be on a safer side. जैसे डिस्ट्रिक्ट जजेस अपने आप को शील्ड करने के लिए अगर बेल अवॉइड करते हैं, इवन इफ देर आर मेरिट्स इन द केस, even if there are merits for a bail petition, then that is wrong. So the judgment was passed, and in this judgment, this was actually passed keeping in mind rights of accused, fundamental rights, and Article 21, no doubt. So all these things have been considered in this judgment. So इस तरीके की चीज़ें अगर आज की डेट में 2024 में अगर हम इसे फॉलो नहीं कर रहे हैं, तो फिर उस पर कंसर्न जताना ऑब्वियस है, एंड CJI हैज़ डन दैट इन द जजेस कॉन्फ्रेंस इटसेल्फ. सो इस पर काम किया जाएगा, एंड अकॉर्डिंगली maybe there might be some change in the mindset of the judges when they understand the importance of personal liberty, which is a fundamental right of a person, and then gradually the things will change accordingly. So this was all that I had to bring to your notice, that this is a very recent current affair in the legal domain. कोई भी queries हो, you can reach out to us, या फिर आप कोई चीज़ ऐड करना चाहते हैं, आप इस वीडियो के कमेंट सेक्शन में हमें रीच आउट कर सकते हैं. Don't forget to subscribe to Legal Bee and prepare 50% faster with us at our exam.